Good afternoon, students. Let's start with our today topic, cyber jurisprudence. It is the study of laws in which directly related to cyber crimes. So all laws will be comes under cyber jurisprudence. In simple terms, it is the extension of a principle of international jurisdiction into cyberspace. So all jurisdiction that is applicable in physical space, we can say in physical world, uh, will applied in cyberspace. The extension of a principle of international jurisdiction into cyberspace. So now all the rules and regulation will be applied under cyberspace. Cyberspace has no physical boundaries. As we know, we can access any resource, we can communicate with anyone with the help of internet. So cyberspace has no physical boundaries. It is an ever growing, exponential and dynamic space. So first one is cyber jurisprudence at Indian level, in which we will see all the acts which is amended by India. So there is two main act: Information Technology Act 2000 and Information Technology Amendment Act 2008. In journal and with particular reference to banking and financial sector related transactions. Before going into the section-wise description of various provisions of the Act, let us discuss the history behind such as legislation in India, the circumstances under which Act was passed, the purpose or objectives in passing it. So firstly, in previous years, in 18th century, 19th, 18th century, all work is performed in paper-based, in traditional systems. So with the evaluation of internet, electronic system, we can say information technology, thus the need of cyber laws is arised. So with the need of cyber laws, there are some acts come in discovery. Two main act in India is Information Technology Act 2000, which is later amended, means some additions is performed on 2000 Act, IT Amendment Act 2008. Genesis of IT legislation in India. Why cyber jurisprudence is comes in this world. Mid-19th saw an impetus in globalization and computerization, with more and more nations computerizing their governance and e-commerce seeing an enormous growth. Until then, the most of international trade and transactions were done through documents being transmitted through post and by telex only. Evidences and records until then were predominantly paper evidence and paper record or other form of hard copies only, which much of the international trade being done through electronic communication, and with email gaining momentum, and urgent and eminent need was felt for reorganizing, recognizing electronic records, such as data what is stored in a computer or an external storage attached thereto. In mid of the 19, all work done on paper based, means when we go to the bank, all work done is organized, maintained in paper based. But nowadays most of the work, means 90 to 95% work is performed in electronic form. So due to the growth of electronic communication, IT legislation is changed. So now we require some laws, some acts that will handle electronic communication, electronic cyber crimes. So that's why these act come in discovery. In India, a centralized statute exclusively for the cyberspace has been enacted with in form of Information Technology Act 2000, which come into force on 17 October 2000. The first, this act comes in public use, we can say in commercial use, 17 October 2000. The act is to act an umbrella legislation of Indian cyber laws. This act cover all the laws, so that's why this is known as umbrella legislation of Indian cyber laws. What is the main objective of IT legislation in India? So to recognize transaction carried out by the mean of electronic in electronic form, the transactions that are done in electronic form is covered by this act. In 19th century, mid of 19th century, or most of the work done is paper based. So with the evaluation of electronic data interchange, the need of some laws that are capable to track the electronic fraud. So the main objective of this act is to provide legal recognition for transactions carried out by the mean of electronic data interchange and other mean of electronic communication. This is the alternative to paper-based method. The communication, storage, and maintenance all done in electronic form. This act cover Indian Penal Code, Indian Evidence Act, Banker Book, and Reserve Bank of India. In later slides, we will discuss about Indian Penal Code, Indian Evidence Act, Banker Book, Reserve Bank of India. This act also amend these acts. It also add some feature in the India Penal Code, Indian Evidence Act, Banker Books, Evidence, and Reserve Bank of India. The act is to promote efficient delivery of government services by means of reliable electronic records. So the main purpose of this act is to deal with the electronic transactions, we can say electronic communication. Information Technology Act 2000 was passed as the Act number 21 of 2000 on 9 June and made effective from 17 October 2000. The main purpose of this act is legal recognition of electronic documents, legal recognition of digital signature, offenses and contraventions, justice dispensation system for cyber crime. So as we see in today work, most of the documents are online. So this is very difficult to differentiate between original and duplicated documents, because the by using some editing, some we can create duplicate documents. So this act deal with the legal recognition of electronic documents, legal recognition of digital signatures. As we know, IT Act 2000 amend Indian Penal Code, Indian Evidence Act, Banker Books, Reserve Bank of India. So now let us see how this act changed Indian Penal Code. Normally referred to as a IPC. This is very powerful regulation and probably the most widely used in criminal jurisprudence, serving as the main criminal code of India. Enacted originally in 1860. The Indian Penal Code is enacted in 1860. But As we know, mid of the 19th century, all work done in paper based. So firstly, this act deal with paper based work. But when information technology evolved, penal code is amended by IT Act 2000. So this is enacted in 1860, but amended many times since it covers almost all the aspects of criminal law and is supplemented by other criminal provisions. Cyber crimes can involve criminal activities that are traditional in nature, such as theft, fraud, forgery, defamation, and mischief, all of which are the subject to the Indian Penal Code. Initially and before mid of the 19th century, this act deal with the theft, fraud, forgery, mischief, but all done in traditional nature. But after the mid of 19th century, means when IT evolved, internet evolved, this act is deal with the theft, fraud, forgery that done in cyberspace. So ITA, Information Technology Act 2000, has amended the sections dealing with records and documents in IPC by inserting the word electronic, thereby treating the electronic record and documents on a par with physical record and documents. Before Information Technology Act, Indian Penal Code deal with the traditional system, but IT Information Act add a word electronics. So now this can handle theft, fraud, forgery, criminal activities in cyberspace. The sections dealing with false entity in a record or false document have since been amended as electronic record and electronic document, thereby bringing within the ambit of IPC all crime to an electronic record and electronic documents. Just like physical act of forgery and falsification of physical records. Initially, Indian Penal Code handle traditional system, crimes of traditional system. So after the amendment with IT Act 2000, it also deal similar crimes, but all but add some new features. Now it can deal with traditional system as well as electronic system. We can say information technology system, technology word. In practice, however, the investigating agencies file the cases the relevant sections from IPC, Indian Penal Code, in addition to those corresponding in ITA, like offenses under IPC 463, 464, 468, and 469, read with the ITA sections 43 and 46 to ensure the evidence and punishment stated at least in either of regulation can be brought about easily. So in Indian Penal Code, for example, for theft, there is section 192. Similarly, for cybercrime, if somebody try to theft in cyberspace, the case will be filed to the relevant section. Means it also submit under section 192. But there is some additional sections that we will discuss in detail in our topic Information Technology Act 2000. There is around 19 sections. We will study about these sections in detail. So there is some additional sections. So investigation agency filed the case to relevant section. And in addition, there are some new sections. That sections comes under 43 and 63 section of ITA, Information Technology Act. So in short, penal code deal with the criminal activities in traditional system, but after the amendment, after the Information Technology Act, so now Indian Penal Code can deal with the crimes of cyberspace. Indian Evidence Act. This is the another legislation amended by ITA, Information Technology Act. Prior to the passing of Information Technology Act, all evidence in a court were in physical form only. So before Information Technology Act, all evidence must be in physical form. We can submit our evidence in court only in physical form. But with the evaluation of information technology, electronic form communication, there is need to submit some electronic records. So with the amendment of ITA, Information Technology Act, this is possible. With the ITA giving recognition to all electronic records and documents, it was but naturally that evidentially legislation in nation be amended in tune with it. Before ITA, Information Technology Act, all evidence must be submitted in physical form, but ITI recognized that there is need to submit electronic records. So word like digital signature, electronic form, secure electronic record, information are used in ITA were all inserted to make them part of evidentially mechanism in legislation. So ITA add electronic documents in Indian Evidence Act. This is an elaborate section and landmark piece of legislation in area evidence produced from electronic device. So we can produce our evidence from electronic device. Any information contained in an electronic record which is printed on paper, stored, recorded, or copied in optical or magnetic media produced by computer shall be treated as a document without further proof of production of original if the conditions like these are satisfied. So with the evaluation of ITA, Information Technology Act, now electronic record can be printed on the paper, it can be stored, it can be submitted in the code as a proof, but some condition must be satisfied. The first one is computer output containing the information was produced by computer during the period over which computer are used regularly. So the first condition is computer output contain information produced by a computer. Means for example, you take print of your bank ledger, means you with some deposit some money, after that withdraw some money, you take printout of that statement, but after that you edit it, means instead of 1000 you add 10 and it become 10,000. So your output is not produced by computer when computer is used regularly. The information derived was regularly fed into the computer in ordinary course of said activities. For example, we deposit some money, our entry is automatically entered by server by bank computer. So information derived regularly, it must be regularly fed into the computer in course of activity, means when activity is done, the record must be fed into the computer. Throughout the material part of said period, the computer was operating properly and a certificate signed by a person. So material must be valid, it must be signed by a person. To put it in simple terms, evidence taken from computer or electronic storage device and produced as printout in electron media valid if they are taken from system handled properly and no scope of manipulation. The first point we discuss, computer output containing the information was produced by a computer during period over which computer were used regularly, means there is no scope of manipulation. It doesn't mean you take a print and then manipulate it. So there must not scope of manipulation of data. Second, ensuring integrity of data produced directly with or without human intervention, etc. There must not be a human intervention. Means, for example, you withdraw money 1,000, but banker enter entry of 10,000. This is not will be accepted by code. So there is no data integrity with or without human intervention. Accompanied by certificate signed by a responsible person declaring as to the correctness of the record taken from the system, a computer with all the precaution as laid down in the section. Let us understand about this with help of an example. For example, you fill any scholarship, and there always a rule. Your result must be verified by your institution. So let us take this example with these three conditions. The first one is there is no scope of manipulation. For example, you take print of your result, then change your grades from A to A plus, B to B plus, and in CGP also. The first one is scope of manipulation. That must not be here. First one is you cannot change your data. Second one is ensuring integrity of data produced directly with or without human intervention, means your data cannot be changed with or without human intervention. Firstly, understand about with human intervention. For example, you take printout of your result, then change from A to A plus, B to B plus without human intervention, means by system. For example, you take a print out of your result. At PTU, your grade is A, but at your college website, it A plus. So without human intervention, because the second point is ensure integrity, mean changing of data produced by computer with or without human intervention. The third one is main certificate signed by responsible person. When you have to submit your document, when you have to upload your document on scholarship portal, you come to your class in charge or HOD for sign and stamping. That is the third point, your certificate signed by responsible person. Means if you want to take any medical certificate, then it must be signed by a doctor, responsible person. And in case of your result, it must be signed by your class in charge, HOD or principal. So these three conditions must be satisfied, then it is valid for as a evidence. However, this section is being misunderstood by one of the industry to mean that computer printout can be taken as evidence and valid as proper record even if they are not signed. Most of the person think that when you take a printout from the computer, you can submit it as a evidence without any sign. But this is not possible. We find many computer generated letters emanating from big corporates with proper space below for signature under words your faithfully, truly, the signature space left blank with a postscript remark at the bottom. This is a computer generator letter and hence does not require a signature. The act does not anywhere say that computer printout need not be signed and can be taken as record. But this act doesn't say anywhere that your document, print of your electronic document is valid without sign. It must be signed. In case of scholarship, most of student upload their result without signature of class in charge, HOD, and without stamp. But it is denied by the scholarship authority. And they mentioned your document must be verified by your institution. So without signature of a responsible person, your document will not consider as a evidence. So because of Information Technology Act 2000, your electronic document can be considered as evidence, but it must be signed by a responsible person. There is no manipulation, and it must be, then it will be valid. Then the third one is Banker Book Evidence Act 1891. So this act was passed by legislature on 1st October 1891. According to this act, in all legal proceedings, a copy of any entry in banker books such as transactions, accounts shall be treated as evidence of such entry. Later, an account book or record showing the transactions of bank, such as book of a or record used as evidence in a court of law. Before Information Technology Act, all transactions related to bank must be taken as evidence in hard copy. Amendment of this act has been included as third schedule in ITA, Information Technology Act. Prior to passing of Information Technology Act, any evidence from a bank to be produced in a court necessitated production of original ledger or other register for verification at some stage with the copy retained in court record as exhibit. With the passing of ITA, the definition part of Banker Books Evidence Act BBA is Banker Books Evidence Act stood amended as banker books include ledgers, day books, cash books, account books, and all other books used in ordinary business of a bank, whether kept in written form or as printout of data stored in floppy disk, tape, or any other form of electromagnetic data storage device. For example, you deposit some money, then withdraw some money, but it is not printed on your account book, your bank account book. It is not printed on that in hard form, but you assess your transactions from transaction statement from internet banking, net banking, and they then take printout of your statement. I repeated again, your account detail, transaction detail, not printed on your account book, means not in hard form, but it is available in electronic form, means on net banking. So you can take printout of your transaction record from net banking and you can take it as a evidence. It will be accepted as a evidence. When the books consist of printout of data stored in floppy disk tape, a printout of such entry certified in accordance with the provisions to effect that it is printout of such entry or copy of such printout by principal accountant or branch manager. First one is it is from certified authority, we can see. A certificate by a person in charge of computer system containing a brief description of computer system and particular of safeguard adopted by system to ensure that data is entered or any other operation performed only by authorized person. The safeguard adopted to prevent and detect unauthorized change of data. Again, it will be valid if it is from the certified authority. There is no integrity, no scope of changes, and there is no scope of data from the unauthorized change of data. So printout of data will be considered valid if it is from the certified authority. There is no scope of change. In short, just like in Indian Evidence Act, provisions in Banker Book Evidence Act make printout from a computer system or floppy disk or a tape as a valid document and evidence proved, such as printout is accompanied by certificate stating that it is true, extract from official record of bank, and that such entries or records are from a computerized system with proper integrity of data, wherein data cannot be manipulated or accessed in an unauthorized manner, or is not lost or tamperable due to system failure or such other reasons. The first one is it must be by certified authority, means it extract from official record of the bank. The second one, uh, it must be in computerized form without integrity. The data is not changed by after within. Data cannot be manipulated. This data is not changed in unauthorized manner. Here again, let us reiterate that law doesn't state any computerized printout, even if not signed, constitute as a valid record. So without signature, it not be considered as a valid record. But still, even many bank of report often send out printed letter to customer with space for signature at the bottom left blank after line your faithfully etc with the remark as post script reading. This is computer generated letter and hence not required signature. Such interpretation is grossly misleading and send a message to the public that computer generated reports or letter need not be signed, which is never mentioned anywhere in nor is import of ITA, Information Technology Act, or Banker Book Evidence. In some cases, for example, you request to bank your account transaction detail from the bank. They send all detail but without signature, and at the last there is a line, this is a computer generated letter and hence does not require signature. But in case of fraud, for example, bank does not send you any document, anybody can write this line at the bottom. So that's why it must be signed. If you take any record from the bank, it must be signed or stamped by bank. So in Information Technology Act and Banker Book Evidence, there is not mentioned anywhere that your document without sign is valid. So if it is not signed, it not be considered as a valid document. Reserve Bank of India Act. According to the act, this act, Reserve Bank of India can provide loans to the bank or state financial corporations. It can provide advances to the central government and state government. It can buy or sell government securities. It has also empowered the central board that has been constituted by Reserve Bank of India to regulate fund transfer via electronic means provided by bank or other financial institutions based on this Reserve Bank of India Act 1934. As we know, Reserve Bank of India is the main bank. It can provide loan to state and central government. But before mid 19th century, amount is transferred in paper base, means cash is submitted to the state or central government. But due to IT information technology, now what is the change in Reserve Bank of India Act due to the amendment is that now electronic transfers also possible. So it allow to transfer via electronic ways. Amended by ITE Reserve Bank of India Act relating to the regulation of fund transfer is now funds can be transferred through electronic means. 15 electron means are possible, such as like NEFT, RTJ, credit card, debit card. So now funds can be transferred through electronic means. It was inserted to facilitate such electronic fund transfer and ensure legal admissibility of documents and records therein. So, Information Technology Act amended these four acts because of IT Act. These four acts can deal with electronic data. As we discussed in starting, there is two main act: Information Technology Act 2000 and Information Technology Amendment Act 2008. The need for amendment was felt for IT Act almost from year 2003 and 4 itself. In 2000, IT Act 2000 is launched, but from 2003-4 amendment is required. Major industry bodies were consulted and advisory groups were formed to go into prescribed reconnaissance in IT Act and comparing it with similar legislation in other nations and to suggest recommendations. So many groups are created that compare our legislation with other nations, other countries, and suggest recommendations. Means there this thing can be changed. Such recommendations were analyzed and subsequently taken up as Comprehensive Amendment Act, and after considerable administrative procedure, the considered amendment called Information Technology Amendment Act 2008. After many meetings, after many discussions, Information Technology Act 2000 is amended and it is known as Information Technology Amendment Act 2008. Information Technology Amendment Act 2008 was placed in Parliament and passed without much debate. Towards the end of 2008, by which time Mumbai terrorist attack of November 2008 has taken place. This Amendment Act got the President asset on 5 Feb 2009 and was much effective from 27 October 2009. So the main feature of Information Technology Amendment Act are focusing on data privacy, focusing on information security, defining cyber cafe, marketing digital signature technology neutral, defining reasonable security practice to be followed by corporate, redefining role of intermediaries. For example, you buy anything from Flipkart and you pay online. Amount from your account transfer to Flipkart account, but there here is intermediary defining cyber cafe, making digital signature technology neutral, defining reasonable security practice to be followed by corporate, redefining the role of intermediaries. Means, for example, you pay online. For example, you buy anything from Flipkart and you transfer some amount from your account to Flipkart, but there is a intermediary, that is your bank. So it redefines the role of intermediary. Recognizing the role of Indian computer emergency response team, inclusion of some additional cyber crimes like child pornography and cyber terrorism, authorizing an inspector to investigate cyber offenses. This is all about Indian level. So two acts are covered: Information Technology Act 2000 and Information Technology Amendment Act 2008. The another one act is Prevention of Money Laundering Act 2002. Is an act of Parliament of India enacted by NDA government to prevent money laundering and to provide for confiscation of property derived from money laundering. This act was amended in year 2005, then 2009, and then 2012. The Prevention of Money Laundering Act seeks to combat money laundering in India, has three main objectives: to prevent and control money laundering, to confiscate and seize the property obtained from laundered money, and to deal with any issue connected with money laundering in India. This is all about Indian level. You can search some other act that is enacted by India related to cyber crime, but these are the main: Information Technology Act 2000 and Information Technology Amendment Act 2008. So our next topic is cyber jurisprudence at international level. In USA, they have first USA enacted some laws like HIPAA, Health Insurance Portability and Accountability Act, SOX, the Sarbanes-Oxley Act, Cable Communication Policy Act, Children Internet Protection Act, Children Online Privacy Protection Act, Cyber Security Information Sharing Act known as CISA, Cyber Enhancement Act of 2014, Federal Exchange Data Breach Notification Act of 2015, National Cyber Security Protection Act, Advancement Act of 2015. And in UK, they have Data Protection Act 2018, Copyright Design and Patent Act 1988, the Absence Publication Act 1959. These are the some international level cyber laws. So now we will discuss about these topics one by one. The first one is HIPAA, Health Insurance Portability and Accountability Act. As we know, this is law of US. So United States Federal Statute enacted by 114th United States Congress and signed into law by President Bill Clinton on August 21, 1906. This act is enacted on August 21, 1996. So now what is the main aim of this act? The Health Insurance Portability and Accountability Act of 1996 is a federal law that required the creation of national standards to protect sensitive patient health information from being disclosed without the patient consent or knowledge. So according to this act, the sharing of patient information without patient knowledge or consent is illegal. So if some hospital, medical organization want to share their information with another one, they have to take permission from the patient. So this is deal with the health related information. We can say it is related to the patients. The purpose of HIPAA: to improve efficiency in healthcare industry, to improve the portability of health insurance, to protect the privacy of patient and health plan members, and to ensure health information is kept secure and patients are notified of breaches of their health data. For example, if some medical organization share their data with another organization, so patient will be know about that. If there is some fraud, there is some breach, so patient will be aware about that. So according to this act, if some organization want to share information, then they have to take permission from patient. The next one is Sarbanes-Oxley Act. This act, enacted in 2002, come in a response to highly publicized corporate financial scandals earlier that decade. The act created strict new rules for accountants, auditors, corporate officers, and imposed more stringent record keeping requirements. The act also added new criminal penalties for violating securities laws. So this law is helpful or applied on accountant, corporate organizations, corporate officers. If there is some illegal, then there will be some penalties, means they will be fined or they can be punished, imprisonment. So this act creates some new rules for corporate officers. We can say in business related rules. The next act is Cable Communication Policy Act. The Cable Communication Policy Act of 1984 was an act of Congress passed on October 30, 1984 to promote competition and deregulate the cable television industry. We can say all things related to cable, we can say television broadcasting is covered under this act. So now see what will be covered by this act. The Communication Act as amended is an expensive statute regulating US telephone, telegraph, television and radio communication. It covers telephone communication, radio communication, television communication. Its 7 sub-chapters regulate virtually all aspects of communication and broadcasting industry. As we know, it is cyber jurisprudence, so it deal with electronic data. So It deal telephone communication. We also know it's electronic form, radio communication, television communication. So it include assignment of frequencies. As we know, in a radio communication, for example, radio communication, their frequency 9.5, 9.4. So this channel can use their frequencies. So it include assignment of frequencies, rates and fees, standards, competition, terms of subscriber access. When we subscribe any channel, uh, take any subscription, there are some terms. So it also include terms of subscriber assess, commercials, broadcasting into public interest, government use of communication systems. So Children Internet Protection Act. This act is enacted in 2000, and the main objective of this act is to address concern about children access to obscene or harmful content over the internet. And the main requirement of this act is to require school and libraries receiving certain federal funding to block children access to obscene material, child pornography, and material deemed harmful to the minors. So the main objective of this law is to block children to access harmful content, and it receives certain funding. So schools and library receive fund from the government uh, to block children access to obscene material or some harmful material. For example, we hear about some games. In that case, some student takes suicide. The news is viral in previous year. Student takes suicide after playing a game. So this act helps to assess. So according to this act, student cannot play, cannot access that game. So this act blocks student access to obscene material or harmful content over the internet. The next one is Children Online Privacy Protection Act. It is passed by USA in 1998 and took effect in April 2000. So main purpose of this law is to protect the privacy of children under 13. So for example, we we create a Facebook account. We enter our name, address, phone number, email. Okay. As we know, we filling our information for Facebook, but student under 13 doesn't can't differentiate. So this law helps to protect privacy of children under 13. So the primary goal of this act is to place parent in control over what information is collected from their young children online. For example, some companies not give access to the children under 13, and some take some information from their parents. After taking information from the parents, they allow to the children to enter their personal information. So it helps to protect privacy of children under 30. We will discuss rest of the laws in our next lecture. This is all about our today lecture.